4 p.m. yesterday. So Ms. Duke may know, but not that I'm aware of.
So, Ms. Rivers, when did you all file your objections?
We filed them this morning, and they are in the court reporter's box. They are written, and a proposed form of order is there. I am now making sure that that both Mr. Michelle and Ms. Tressler are given them if they haven't already.
It's my understanding we do not have access to Ms. Rivers' box. And I have not seen any objections filed or served upon me. I haven't seen them.
As I say, Your Honor, I have just told my staff to make sure that Mr. Michelle and Ms. Tressler get them. As I say, they are in writing, but of course we could present them orally, and they're pretty short.
All right. Yes, I found them in the box. There are 9 objections.
Typically, Your Honor, in summary judgment practice, my understanding is objections or replies of that sort are supposed to be served at least 3 days before the hearing, so I could have an opportunity to respond. All
right. Well, Mr. Michelle, you want to give me the cite to that rule?
Yes, I believe it's Rule 166 AI and applicable case ruling. Let me pull that real quick. And Judge, I apologize. I was unaware until a few minutes ago that anything had, well, I guess it was just filed a few minutes ago. And if I may, Your Honor, if I could speak to my co-counsel and her paralegal to assist us with the box, as I'm in Fort Worth, Your Honor, and
Judge, if I interject, this is the court reporter.
Yes.
I was just going to let counsel know everyone should have access to the entire case folder for this hearing. We did implement a new box procedure here in Travis County where our individual courts do not start the process. It started with the court administrator's office, I believe. And so if you're having trouble today or in the future, please reach out to our court staff before the hearing so that we can get you set up properly. And I will check now to see whether or not you have access to the entire folder, Mr. Michelle.
I appreciate that. Thank you very much.
All right. And I'm looking at the folder, and I did find there's a folder called Respondents OBJS to Petitioners MSJ. It was filed at 8:52 this morning, and that folder was set up. These aren't set up the way we usually do it because of that new process that literally went into effect today, I think. So if you're struggling with it, I get it because it's brand new. But I was able to open the folder labeled Respondents Objections, and it's just basically a 1-page list of 9 items.
I will say I'm trying to preview with it having been filed at 8:50 or submitted at 8:52 this morning. In a summary judgment proceeding, issues not expressly presented at the trial court by written motion, answer, or other response shall not be considered on appeal as grounds for reversal. So I would say that at the very least, the objections have to be presented in writing.
All right, and I think that's what this document is.
I would agree. With the court's permission, if you allow me to speak to my co-counsel, I don't know if they've had success in looking these things up yet.
So, are you asking if you could go to a breakout room with your co-counsel, or you just want to turn off your camera and microphone and call her, or what is it you want to do?
Perhaps, and Your Honor, I have not had, obviously, just having now learned of this and not had an opportunity to review them or respond to them in kind in writing. I would object that the objections are untimely. Obviously, I haven't had time to pull a case for you on that.
I assume that you all filed these objections as well as uploaded them to the box, Ms. Rivers?
I assume so, Your Honor. I have made sure that my staff knows to do that. I will see if that's been happening, has happened or not. I've also asked them to make sure they send them directly to Ms. Tressler and Mr. Michelle. And I should say, Your Honor, that I have no objection to the court granting Mr. Michelle some time to review and respond after the hearing today to the objections. This is a rather complicated summary judgment motion with a lot of evidence, and I don't know what the court's intentions are concerning taking it under advisement or ruling today, but as I say, the objections themselves need not be addressed immediately. I don't think they need to be.
All right. Well, I'm looking at 166A, and while it's true that there are deadlines for filing 21 days before the hearing and at least 7 days before the hearing for summary judgment evidence to oppose the summary judgment, I'm not aware of a deadline for filing objections. But if I'm missing something, I'm happy to look at it. In any event, I think Ms. Rivers' suggestion is a good one, which is let's reserve the issue on the objections to the summary judgment evidence. What we can do is talk about after the hearing is over on the summary judgment motion, a timeline for dealing with it. Is that acceptable, Mr. Michelle?
Yes, Your Honor. I think, as I understand the court's suggestion, that we proceed on with the summary judgment hearing, and we could address the objections at a later time. I guess the issue could become moot, or even if the court were to grant or deny the objections, they may not affect the overall court's ruling in any event. So I think it would be beneficial to go ahead with the hearing on the motion. That way, since we're all here.
All right. Well, let's do that then. And can you tell me the date the summary judgment motion was filed?
Yes, Your Honor.
Oh, I see. 11/21. Is that it?
Yes, November 21, yes.
All right.
And actually, our filing and our hearing today is being done in accordance with an agreed scheduling order by the court. So we are in the timeframes previously ordered by the court.
All right. Thank you. Well, let's go ahead and set aside the issue about the objections to exhibits. And Ms. Rivers or Ms. Block, you may proceed.
Thank you, Your Honor. Before we proceed, may I ask if we are on the record?
We are not.
Would it be possible for us to be on the record, at least for a short while? I will just make a comment for the record about how we're going to be handling the objections to summary judgment evidence. And then what I'll do is I'll proceed into the argument.
All right. You may do that. And then after you make a statement and Mr. Michelle has any opportunity to make a statement, then we'll excuse the court reporter.
All right. On the record then, is that right?
Yes.
Thank you, Your Honor. Your Honor, my name is Rochelle Rivers. I represent the defendant or the respondent, Ali Hussein, in this post-divorce action filed by petitioner Iram Hussein to divide allegedly undivided property during a divorce. This is a post-divorce proceeding. We are on the record right now on the hearing on Mr. Hussein's motion for traditional and no evidence summary judgment. And before we came onto the record this morning, I notified the court that we have filed and presented to the court, uploaded into the court's hearing box folder, Ali Hussein's objections to Iram Hussein's summary judgment evidence and arguments. We have had discussion off the record prior to the initiation of the hearing concerning the fact that petitioner's attorneys, Mr. Michelle and Ms. Tressler, have not had the opportunity to review those objections, wish to have the opportunity to review them and address them. And I have had no objection. I've indicated I have no objection to the court providing them time after this hearing to do that. I do want to make sure that the record is clear that we have asserted these objections. Your Honor, in the materials provided to the court is also a proposed form of order on those objections. And so we ask the court to take both of those matters under advisement before ruling on the motion for summary judgment. Thank you.
Mr. Michelle, your response?
Thank you, Your
if
thank you,
any.
Your Honor. Yeah, very briefly. Thank you, Your Honor. I appreciate it. My understanding was that some objections were uploaded to the box at approximately 8:52 this morning, and that Ms. Rivers' office has indicated that she has filed those of record with the court as well. I am seeing an email that came through. I'm not sure if that's the email that contains the objections. That says at 9:21 this morning. My understanding is the court is going to proceed with the hearing on the motion for summary judgment, and that the objections will be taken up at a later time, so that we also may be able to excuse the court reporter since we are going to be proceeding into argument. I wanted to also reiterate, Your Honor, that Ms. Rivers indicated to the scheduling order. The scheduling order provided Mr. Hussein had filed 3 previous motions for summary judgment. And in the scheduling order that we eventually got a trial setting for, we are set for final trial in about 2 months. We did preserve that. We said petitioner does not agree that the amended and additional motion for summary judgment is appropriate. So I just wanted to complete the recitation of that scheduling order.
Your Honor, while I have this on my mind, I will make a short comment about Mr. Michelle's comment. He indicated that defendant has filed 3 prior motions. We've had 1 prior hearing on defendant's then filed. There were 3 separate motions which divided claims. Each one addressed different claims, but they were all considered together, and they essentially were briefed and presented to the court and determined by the court together. And there's only 1 prior order. And we also understand the law to be that there's nothing to prevent Mr. Hussein from trying a second time to have the court consider this matter and dispose of it on summary judgment.
All right. I was just taking a look at the docket notes, and I do see that y'all have had a hearing back in September on respondents' motions for summary judgment, and that it was denied. I guess the hearing was September 9th before visiting Judge Rose. And
what year was that, Your Honor? Do you see that?
Oh, I do. 2021.
Yes, thank you.
And
yes, the case has been significantly developed since then.
All right. And I do say that the motions were denied on September 13th of 2021.
And in response, Your Honor, I would say that really no new discovery has taken place. We had already taken the depositions of the relevant parties, so there really wasn't any new development. But I can reserve that till our argument, Your Honor.
All right. Well, I do see a hearing on February 12th of 2024. Is that your trial setting?
Yes, Your Honor.
All right. Well, I will keep that in mind. So now we will go off the record and I will hear your argument, Ms. Rivers.
Thank you, Your Honor. I appreciate it. May I also have authority to share screen?
You may. Any of you are welcome to do that, and you don't need to ask.
All right, thank you. Let me start by saying, Your Honor, that this is a case in which it's a post-divorce case in which the petitioner, Iram Hussein, seeks to divide property that did not exist at the time of divorce. There are a number of things the court may discern from review of the summary judgment evidence. And we have divided the facts into 3 basic arguments. The first one is that although the petitioner, Iram Hussein, argues that she thinks that Mr. Ali Hussein's denial that any interest in Flux 7 Labs existed at the time of divorce, if there had been any such interest, it was already divided by the divorce decree. We, of course, invite the court to look at the divorce decree, part of the summary judgment evidence, and we urge that petitioner Iram, with the court's permission, I will refer to the parties by their first name, as the appellate courts typically do.
That's fine.
Thank you, Your Honor. So Iram ignores the clear language of that decree that awarded to Ali, quote, any rights related to any stock option plan or other benefits, emphasis on the other benefits by me, existing by reason of his past, present, or future employment. Though Mr. Hussein, Ali Hussein, denies there was any such interest, Ms. Hussein, Iram, essentially alleges he's lying. And if that is the case, if the court were even to accept that we think unsupported allegation, then it is divided. Second, the interest that Ali Hussein obtained, acquired in Flux 7 Labs was acquired after the divorce. Iram sidesteps the predicate requirement that she must show that property actually existed during the marriage. She ignores that by speculating that Ali lied during the divorce when he unequivocally repudiated the existence of any such property interest and any hope of obtaining such a property interest. She knew during the divorce that he worked for his friend, Otter Suleiman, Otter, A-A-T-E-R, Otter, at Flux 7, but he repudiated any ownership interest or hope of ownership interest. Iram presents no evidence before this court today disputing what we urge strongly is Ali's conclusively proved showing that he acquired his interest in Flux 7 2 years after their divorce. 2 years. Third, and perhaps most importantly for this court, Iram knew that she had reason to suspect he was lying. She knew she had an interest, or she revealed that she had an interest. As she stated it, she knew that, quote, half his shares in Flux 7 were hers legally, and she threatened to make that an issue. This information we urge at the very latest, which she gave to him a few months after the divorce, at the very latest, began the clock ticking for her having to bring her claim. So, Your Honor, I'd like to very quickly show you what—
Hang on, I didn't fully understand your third point, but I see that you're going to go through it in more detail in a minute.
Yeah, she knew she had a claim within the limitations period. She sat on it far beyond the expiration of the limitations period.
Got it. Thank you.
She knew it, and she didn't do anything about it until too late. So, Your Honor, I'd like to take a few moments just to walk through what I think are the grounds that we have asserted in the motion. I do ask if everybody can see my screen. I'm going to put some of this up on slides. Is it visible?
It is to me.
And Your Honor, I know that you're muted right now. I think maybe
I know I keep muting myself because I can't stop sneezing, but but then I forget that I've done it all these years after we first started on Zoom. You'd think we'd all remember, but we don't. So I'm just wanted to say that if you have not put a copy of your PowerPoint slides in Zoom, either of you, if you're going to use the PowerPoint, please do that. I'm in Box, and I actually do see that it appears that you've already done that, Ms. River, so thank you.
Yes, indeed. Thank you. All right, so the grounds that we are presenting to this court today for summary judgment start with the argument and the showing, we think the conclusively proved showing, that the stock interest that she seeks in this lawsuit were already awarded. There is no undivided property, so she has no claim for an undivided property. Second, we say that the proof before the court conclusively shows that he acquired his interest after the divorce. And third, we argue that limitations bar her claims. So to go through each of these very individually, we show the already divided argument as having been proved by starting with our motion for summary judgment to Exhibit B, which is the agreed final decree of divorce. The agreed final decree of divorce on page 2 awards property to husband. That includes all right, title, and interest and claim in and to on page 3. The important point here is all sums, the proceeds therefrom, and any other rights related to any employee stock option plan, or, and this is the huge catch-all, Your Honor, or other benefits existing by reason of the husband, that's Ali Hussein's, past, present, or future employment. This grant, as I believe the court is well aware, is an all-inclusive grant award to husband Ali Hussein of this broad category, including benefits existing by reason of his employment. He was employed at Flux 7 during the divorce, and he continued to be after the divorce. And we urge that although he did not have any interest during the marriage, he was a mere employee. Even if he had, as the petitioner Iram urges this court to conclude, even if he did have that, again, which we deny, if he did, it was already awarded. So there is no undivided property because of that award. He was awarded in the day after the divorce. He had all benefits that he might have had that existed by reason of his employment. And that is the whole point of this entire lawsuit. She thinks he had some benefits for working for his friend Otter at Flux 7, and that those benefits were not revealed to her, not disclosed to her, and somehow he was lying about that fact. Doesn't matter because he's got it. So the point that we make about that is that Iram said in this lawsuit, in her deposition, that she knew anything you have over there, you meaning Ali, is divided. Not only did the decree say that, but she acknowledged to this court in this lawsuit, anything he has over on his side is divided. Your Honor, we point out the fact that she knew that in the context of the post-divorce, post-Texas divorce, religious divorce proceedings that were going on in Pakistan. There were disputes going on at that time, and she knew what those disputes were, and she understood the decree to mean that anything that he has is divided, is his, and she was arguing that in the religious divorce in order to rebut his claim in the religious divorce that under the religious divorce law or rules of that forum, he was entitled to get his family's jewelry. You will see that in the depositions that each of them gave. And she basically said, no, that's not right. She was arguing in the religious divorce that anything he has on his side is divided. So we think there's no question that not only does the decree say that, but she knew the decree said that, and she used it in the subsequent post-divorce religious divorce proceedings. Now, the second point we make to the court is that Mr. Hussein, Ali, did not acquire any interest during the divorce. He had no interest until after the divorce. We point the court to these facts, and it's pretty interesting. The November 4th, 2013 date is the date the divorce was final. That month, after the divorce was granted, you will see in both Ali Hussein's and Otter Suleiman's affidavits that they went to a conference. They went to an reInvent conference put on by Amazon. I think it was called AWS, Amazon Web Services Conference. That conference, both Ali and Otter talk about now and in other forums as being the turning point in their work for Flux 7. a turning point because, as they explained, it was when they saw how they could revamp the company. They could change the direction of the company. They could do something different. What they saw, Your Honor, this is interesting. In November 2013, they were seeing that cloud-based services were going to be a thing. Were going to be something big. It was going to be something that they could take advantage of and help build a company out of it. It was the foundational realization on which they pivoted and put their attentions to. And in order to try to go after that opportunity that they were going to change their company, Ali stopped taking a regular salary. He had been a salaried employee before that. And in order to make this change, to do this pivot, he was going to, and so was Otter, going to put sweat equity into the company. And so having stopped taking a regular salary and starting to do something completely different was the foundation of the subsequent success that Flux 7 enjoyed. Prior to that Turning Point conference, they were losing money. They didn't have anything. The company was essentially worth nothing. And this is what changed everything. Not only did Ali stop taking a regular salary, what Ali and Otter talked about was to see if they could make it a go. They wanted to see if each of them, Otter, the founder of the company, he started the company, I think, back in 2002 or 3. His deposition says many years before, a decade earlier. He wanted to see if both he and Ali could essentially make equivalent financial contributions to the company. Ali, as a result of having been at that AWS conference November 13th through 15th, 2013, he brought into the company a large contract. That large contract was helpful in allowing them to focus on the turning point in their company. Now, it took a long time for them to do the work necessary to see if their new idea was going to manifest. It was not until May 2015.
When was the large contract?
I believe it was in early 2014. I don't remember if that specific date is given in Ali's affidavit, but I think it's clear from the affidavit that that's part of what he did as part of the shift in the focus of the company. So it was a thing that he did, and it was part of his contribution. He contributed sweat equity and he contributed success in bringing money into the company, all after they identified this as the new direction of the company. I make the point. Yes, ma'am.
In Ali, this is Heidi Block, also co-counsel for Ali Hussein. In Ali Hussein's affidavit on the second page, he describes that conference. And he says, I met someone at the November 2013 reInvent conference, which led to a large contract. So his affidavit establishes that it was after the divorce.
Thank you. I make the point of the along the timeline when Ali, the owner of the company, decided that they would restructure the company formally. The sweat equity contribution, the contributions by Ali of bringing in new revenues, the work that they did continued for a period of time. And then in May 2015, year and a half later, he engaged his attorney, Brian Spross, to draft paperwork to restructure the company. This is the important point for the court to take note of, because it was not until then that Ali decided to proceed with not only the restructuring of the company, but also with the restructuring of the allocation of ownership of the company. So, for example, one of the documents that Brian Spross drafted, he drafted a form of it, gave it to Ali Hussein, who then filled in the blanks much time later. One of the documents was a stock restriction agreement. The stock restriction agreement was effective January 20, 2016. Your Honor, I think that it is reasonable for the court to conclude from this evidence that Ali Hussein did not acquire his interest until January 20, 2016. There is a requirement under Texas law that any ownership interest that any shareholders agreement, such as that agreement we just saw, and a subsequent one as well, must be contained in, well, these are the things that must happen under law, that the shareholders had to vote and approve the restructuring. It must be written. And again, it was not written until January 2016. And the shares may not issue until the consideration has been paid. The evidence shows that Ali did not pay money directly to Ali. What he did is he made his consideration given for his shares was the sweat equity, was the work he performed for the company without pay. So the law provides that he would have no interest until it's written, until the prior owners voted to approve it. So that, Your Honor, and those documents are in the summary judgment proof. There is also a stock, let's see, I think there's a stock. There's that stock restriction. There's another one. There's another document that is basically a stock option plan that that decided that followed the conversations that the parties had, that Ali and Otter had about seeing how it goes. So by 2016, they had been seeing how it goes for a year and a half, and they decided that they would have that Ali wouldn't have complete ownership right away, that they would accrue over time. It's basically an option vesting period. And they said that option vesting period would have begun on January 2014. Again, that's when he stopped taking a salary. And after they'd gone to the the AWS conference, and month by month after that, I guess Otter decided that he was doing his required work in order to be a shareholder of the company, and so they documented that month by month in the 2016 other documents. That she knew half of his shares were hers legally shortly after the divorce. The smoking gun document for this court's careful review is Ali's Exhibit G. Exhibit G is an email from Iram to Ali dated May 28, 2014. In that email, she says, now, half your share of Flux 7 Labs, etc., belongs to me legally. I might decide to make that an issue. Your Honor, she says that, I'm going to go backwards, in the context of angry statements to him, in the context of the religious divorce, and she knew she could have pursued it if she wanted to. So the thing to discern from this email is that by that date, by May 28, 2014, she knew she had a legal claim to half of his interest, and she threatened to make that an issue. And she did not make it an issue, pursue it, until over 6 years later, when this lawsuit was filed on July 16, 2020. The statute of limitations that apply to all of her claims is maximum 4 years. There's a 2-year statute of limitations for dividing undivided property. And it's 2 years from the date he unequivocally repudiated the existence of the ownership interest. Your Honor, I think that there's no dispute in the record. She makes it very clear she understood he repudiated the existence of any ownership interest in the company. Her whole point is she thinks he lied. But an unequivocal repudiation can also be the truth. And so the speculation that he lied, Your Honor, we say is not competent summary judgment evidence. The 4-year statute of limitations would be for her tort claims, breach of fiduciary duty. And by the way, Your Honor, as a matter of law, Ali Hussein had no fiduciary duty to her during the divorce. During the divorce, they were both represented by lawyers, and the fiduciary obligation ended at the initiation of the divorce. That 4-year statute also bars her fraud and her constructive fraud claims. And so, to go backwards just for a moment, 4 years max after May 28th, which is the latest time that she knew or should have known that she had expired long before the suit was filed. Now, just to nail down these factual issues, he repudiated his interest back in September 2013 during the divorce. This is his divorce deposition on September 13, 2023. He said he has no stock options. He has no other benefits. He has no equity in the company, and there have been no discussions about ever having any equity in the company. And nothing was said to make him believe he might ever have any equity in the company. That is an unequivocal repudiation. That started the 2-year. She nonetheless, in her deposition, says that she suspected he might have an interest during the 2013 divorce. She suspected it. But what Ollie says, part of her suspicion has to do with, actually it's her only real evidence, is that he and Otter called Ollie a co-founder of Flux 7 on its website in 2014. They called him a co-founder in January 2014. That is what Iram says triggered her belief that Ollie was an owner. That makes sense because the website said that. I believe it was in January 2014. And she then in May 2014 wrote that nasty email saying half of his interest is hers legally. So co-founder is an important word in this summary judgment because it's the trigger for her. Co-founder is what gave her reason to believe he was lying. She did due diligence. She said, I did an internet search for publicly available information. That was during the divorce, before November 4th, 2013. So she knew internet searches were...
Remind me again the date on which the website said he was a co-founder?
Yes, it is January 28, 2014. That is Ollie's Exhibit D.
Thank you.
Exhibit D. And Your Honor, I want to point out, although it's important, I don't think I have a slide about this. His Exhibit E is the Flux 7 webpage from November 28, 2013. November 28, that's Exhibit E. November 28, 2013 did not list him as a co-founder. So these two websites essentially corroborate the foundational pivot point that happened at the AWS conference, November 13 through 15.
Wait until Ms. Rivers returns and then we'll get started. All right, you may continue, Mr. Michelle.
Is my screen sharing, Your Honor?
It is.
Thank you, Your Honor. All right, so as we were saying, in our response, and I did try to incorporate as much as possible for the court some of our exhibits so they would be contained within the response for the court's convenience, but we can see that we've outlined through both the deposition testimony of Ali and Atar that they were friends and worked together and always wanted to start their business and even had discussions in 2011. What has happened is, as the court will note that, and I'll get into this more in the limitations part, but none of this was known to Iram until it came out on a public notification that Atar and Ali had sold their interest to NTT Data. So as we go here, they're starting to make their rounds of interviews in 2019 and 2020, and Atar, Ali's 50-50 partner, gave a very detailed discussion, says, where they're asking, how did you finance your growth? It's you and your partner. You guys were equal partners in the beginning. And what's very interesting, Your Honor, is they actually discussed not being equal partners and said, we started out as equal partners. We actually had slightly against the conventional wisdom. We actually did not like a 51-49. We actually did a 50-50 between the two of us. They go into about the mutual respect. They've known each other for 10 years or longer. And we discussed the possibilities of even doing an uneven split. But we felt that it would be more motivating for the both of us to stay equally engaged with equal skin in the game. And I confirmed that with his deposition in 2021, and we've attached that as well. And then Ali also confirmed in his deposition that Atar did in fact admit that they were equal partners from the beginning.
Do you have any quotes from either of them saying we were equal partners starting in April 2013, or saying something other than in the beginning without giving a date?
We will, yeah, and we will get to that, Your Honor. We're going to get to those quotations, but I wanted to affirm that they were equal partners from the beginning, and that's what they both testified to. And Judge, you will see as we get further along this is that Ali Hussein's testimony has changed. When I took his deposition, he said he became an owner in January of 2014. That's in his deposition. Then his affidavit says it's 2016. So he can't keep his own story straight. And then we have more statements about, which I confirmed through their depositions, is that you were partners, your partners, Ali Hussein. As we move forward, and this is in the paperwork, and I'm sure the court can review it on as we go forward. But here they are. They talked about they founded it in 2013 by Atar Suleiman and Ali Hussein, not 2014, not 2016, 2013. And they both confirmed it in their deposition testimonies. Ali left his job in April of 2013 and started with Flux 7 in 2013. Granted, they went in November shortly after the divorce, but in order to get an award for Flux 7, as they were both awarded, Ali and Atar, in November of 2013, were given an award that had to be submitted prior to then. Atar himself lists himself and Ali as co-founders.
What's Owler?
Oh, yeah, it's an online presence on the internet, Your Honor.
All right, but it's not the same as Flux 7.
No, Your Honor. It's just an announcement for technical people who are out there. Atar talks about him founding Flux 7 in 2013. Ali's LinkedIn pages states he co-founded Flux 7 in April of 2013. And Ali himself says in April of 2013. I and my co-founder, Atar Suleiman, bootstrapped Flux 7 Labs as a service company until its acquisition in December of 2019 by NTT Data Services. Once again, they both confirmed that's what they said. I asked them both in their deposition testimonies about that.
And again, I'm curious to know whether at any point they used words other than co-founded.
They used 50-50 equal partners from the beginning.
Right. So I'm just wondering if you could find any statements that say we were equal partners and have that 2013 date in it, as opposed to from the beginning when they talk about an equal partnership.
Judge, the most we could find is the fact that they said they were 50-50 partners from the beginning. Clearly, it was founded in 2013, not 2016. We have their own admissions and sworn testimony that they were, that their LinkedIn pages show that they were co-founders in April of 2013. But I did not, because they're denying under oath as of even currently this litigation that when I take their depositions, they're denying that he had any interest in 2013. So no, I was not able to get them to admit. I could only through their own admissions made out on the record 7 years later, finally admitting that they were 50-50 partners from the beginning, tying it to the co-founding in April of 2013 by their own admissions. That's about as, for summary judgment purposes, Your Honor, I would certainly think that is enough for a finder of fact to surmise. But, and you'll see as we move forward, how do I get to the document?
So the fact issue in your mind with respect to all this is a question of whether in the beginning it's the same as April 2013.
I will tell you this, Judge, I think it's overwhelming. They both testified that it started in April of 2013.
Right, but the thing that Mr. Rivers stresses is that nobody says that Mr. Hussein was a co-owner from the beginning, but only that he was a co-founder from the beginning. Well, and ownership and founding aren't necessarily the same.
Yeah, and Your Honor, I respectfully disagree. Ali,
I know you do, but
not to that point, Your Honor. They say they're 50-50 partners from the beginning, right? Not just co-founders, but partners. And Ali and Atar stated that they even talked about from the beginning. We talked about doing a 51-49, but we said we wanted to have equal skin in the game from the beginning. Then time to win.
Are there any issues? Well, go on. I don't mean to interrupt.
Sure. I appreciate your questioning, Your Honor. I deposed both of them, and here's an excerpt from Dr. Suleiman, Atar Suleiman's deposition, once again going his LinkedIn page and saying that you were listed as the to Mr. Hussein's about the founding it and listed you as the CEO of Flux 7. Yes, and he says, I said testifying. He said, I asked quite starting back in April of 2013, and he answers correct. Yes, sir. Moving forward, Your Honor, if you're going to say, do I have their sworn testimony in July of 2021 admitting that I certainly don't have the deposition testimony admitting, because they deny as of today. I will say the testimony before the court is conflicting even as to what they say he acquired in ownership interest. What is
the form of business? Flux 7?
Yeah, well, now it's been sold to NTT Data. It was created into a conversion, as Ms. Rivers has set forth documents, I believe, in an LLC.
So it was formed as an LLC, and do you have the formation documents?
No, the documents that they presented were in 2016. That it wasn't formed that way, but what the interest that was given between the two in April of 2013 was later papered in 2016, as Ms. Rivers has presented.
So we don't have any evidence dating back to April of 23. I'm sorry, of 13. See, I can do that too. We don't have any evidence showing the ownership in April of 2013.
We do not have any documentary. We've requested it, but of course we don't have any. Also, they've not presented any pay stubs, any W-2 statements to show that he was an employee at that time, as opposed to a co-owner.
It doesn't say somewhere that neither of them were taking a salary?
Yes, I believe so, Your Honor. Neither one of them were taking a salary, is my understanding. I know Ms. Rivers has said that he was receiving a salary as an employee, but I didn't see any documents that showed that he was receiving a salary.
All right.
And of course, Your Honor, our evidence and reasonable is that, the history, they're getting together in 2011, Ali quitting his job, he's joining ATAR in April of 23, their own statements that he was a co-founder in April of 23 and started from the beginning of April of 2013 is we believe that is certainly some evidence of an interest in property, which is, we've quoted the broad scope of what an interest of property is, and also specifically what the reference to that would be under Chapter 9. As an aside, Your Honor, should any of these other issues, I'll get to it, but a partition action does not have a limitations provision. So if you're a joint owner of property, you can ask for a partition at any time. And there's a short issue. I would like to, if I could, Your Honor, Ms. Rivers asserts that it was awarded, his interest in Flux 7 was awarded in the final decree of divorce. She points to the retirement section of the final decree of divorce. I will say this first and foremost, clearly Flux 7 is not listed as being an asset that was awarded to him. So it's undisputed that Flux 7 was not awarded to Ali. In contrast, there was another business entity known Rambling Walk. And if the court, I'm sure you are, I know you're a court of general jurisdiction, that the divorce decrees are broken up usually in the forms, the Texas family bar manuals that we all use. The business section talks about the business known as Rambling Walk. That was in paragraph section 8, which was specifically awarded to Mr. Ali Hussein. Okay. In contrast, what they're relying on is the retirement section. And in fact, it says all sums, Your Honor. And if you'll see, and they do not quote the entire provision of the final decree of divorce of that section, which I do. It's section 4, and it says all sums. And continues on with the paragraph, and she stops about as a result of his present employment. And then they talk about specifically, but not limited to, the Schwab 401k plan. That is once again consistent with the award of a retirement interest and not a specific award of a business interest. The Texas family.
What's the name of the business he was awarded?
It's called Rambling Walk.
And where's that awarded?
Right here, Your Honor. I'll highlight it if it shows.
I'm just wondering in what section?
It is under the property section of the final decree, that the section that is awarded to the husband, paragraph 8.
I'm just wondering because you said section 4 is where they're dividing retirement benefits. And so I'm just wondering where that statement, that paragraph 8 appears in what section?
Very, very good, Your Honor. Very, and please, things are in my head and I know where the sections are, and I do not always communicate them very well to the court. So thank you for asking that. So section 4 is typically, and I'm about to get to the decree tracks the Texas Family Bar Practice Manual. Section 4 is the retirement section. You'll see section 8 would be the business, and I'm about to, and there's the Rambling Walk that was awarded to, excuse my typo. There is the section 4 right here, Your Honor, that awards the 401k. And as I pointed out, finally, the agreed final decree of divorce follows the Texas Family Law Practice Manual forms, which has a section F of form 23.1 for retirements and employee benefits, and section K for businesses. and we try to recreate that specifically here. It is Form 23.1 and employee retirement benefits. So that's the section form that goes to the 401ks. You'll see they do P6. And then you can continue on to Section K, deals with business interests, talks about closely held entries. And typically when you do those, just like they did with rambling, they specifically named it in that section. And of course, Flux 7 was not used. So, Judge, I believe a plain reading of the final decree of divorce does not award him a business interest in Flux 7. Carrying on, it's undisputed as part of the fraud allegations that he did not disclose his ownership interest. On page 19, we've quoted the deposition testimony of Mr. Ali in 2013. Eram's lawyer, I thought, did a fine job at the time. As you're doing, when you're taking these questions, you're trying to fish around and ask it as broadly as you possibly can. Do you have an equity in the company? No. Do you have any discussions with anybody about ever having equity in the company? No. Has anybody ever said anything that would cause you to believe you might ever have equity in the company? And so this is in September, and he answers no. He asked that continue on. Do you have an agreement with them to get equity in the company after the divorce is over? The answer is no. He asked, are you hoping to get equity in the company after the divorce is over? No. And granted, Judge, as the lawyer in this case, what would I argue from this evidence is clearly that is unbelievable testimony, because he later on testifies that he got an equity interest in January of 2014 in his deposition testimony. So once again, Judge, when you look at this evidence, is there some evidence? We believe so. Are the reasonable inferences in the most favorable to the non-movement was he trying to hide that? I said, I think clearly he was. He did not disclose any ownership in his inventory and appraisements during the divorce as well. And he admitted that he did not disclose any, but that he did disclose his ownership interest in Rambling Walk. Of course, Judge, you're very familiar with this. I've cited much of the standard of review when the court is to consider a traditional motion for summary judgment and a no evidence motion for summary judgment. We've tried to bullet point out some of these summaries, Your Honor, on pages 22 and 23. We've already gone over that questioning, Judge. You've asked me what is our evidence. Clearly, and I know I'm repeating myself here, is that they said they are business partners, 50-50 from the beginning. Co-founded in April 23, quits his job in April 23, starts at Flux 7 in April 23, and holds out to the world post-sale that he was a co-founder since April of 2013. If I said 2023, I apologize. Now he submitted his affidavit in support of his fourth motion for summary judgment, which he talks about his ownership, as Ms. Rivers indicated, not until 2016. We believe clearly there is an ownership dispute as to whether or not he had an interest in property that was not divided. Section 9.201 states if a court of the state failed to dispose of property subject to division and find a decree of divorce or annulment, even though the court had jurisdiction over the spouse or over the property, the court shall divide the property in a manner the court deems just and right. With regard to, we mentioned a lot of the issues that are raised about the property interest and how it's, we believe there's a fact issue there. With regard to the limitations period does not begin to run on a Chapter 9 limitation until ERM unequivocally repudiates an ownership interest in Flux 7, not Ali. So
let me just ask. So the company was purchased in what year did you tell me?
They announced it in 2019, I believe, Your Honor.
All right. And how much did Mr. Hussein get?
$5 million.
And so is that what's at dispute, that half of that $5 million should, or some part of it should have gone to her?
Yes, Your Honor.
So we're not looking at a current valuation. We're looking at the value at the time of sale.
Correct.
Actual money that changed hands.
Yeah, for lawyers, sometimes it's a little easier. It's been monetized. Yes.
And when was this suit filed?
In 2020, shortly after she heard about the announcement. She retained lawyers and filed suit.
All right, thank you.
And so this is an affirmative defense that they've asserted for limitations purposes. Of course, they have to conclusively prove as a matter of law on their affirmative defense that all elements have been met. So their argument is a little bit contradictory because even today they claim that Ally did not have an ownership interest in 2013. How on earth could she have proven that if even today they're saying he hasn't owned it? We've detailed in length the due diligence that ERM had done in trying to do it. And when you do divorce cases, obviously there's no public records, no public documents. She got the sworn inventories, got the sworn deposition testimony, sent out discovery, all of those things trying to verify, but he unequivocally denied any ownership interest, and that's part of the fraud claim as well. With regard to the accrual of limitations specifically under Chapter 9, it has to be when she unequivocally repudiates her ownership interest in his property, and that has not happened. I'd argue as of today that hasn't happened. In fact, she's filed suit for it. They can't trigger a date where she unequivocally repudiated an interest in Flux 7 that he's denied that he ever had. In short, once it was made aware through a public announcement, she immediately conducted due diligence, hired lawyers, and then filed suit that brought us here today. So as a matter of law, we don't believe that the summary judgment establishes, even as the court is aware, the one case I've cited just as a way of example, it was 32 years later. Here, it wasn't until this was first known. With regard to ERM's statements about Flux 7, of course, she had no knowledge of ownership interest in Flux 7, and Ally had unequivocally denied even a hope of any interest in Flux 7. Of course, she could never find any evidence or proof until their own admissions. With regard to the anger in her email, we've extensively addressed that. She was upset about the jewelry and the Pakistani divorce, and she testified that yes, there were many ugly things said by both sides, but that she had no evidence of any ownership by Ally in Flux 7 in which to pursue. And of course, as we know here today, he's still denying an ownership interest in April of 2013, or while the divorce was pending. There is, in the case law that we've cited, it has to be an unequivocal repudiation of the ownership interest of ERM in Flux 7, not Ally's position. So we believe that is going to fail on its face. Alternatively, we set forth a basis for tolling for the discovery rule and fraudulent concealment. I think the fraudulent concealment is self-evident because today, if he owned an ownership interest in Flux 7, he has continued to fraudulently try to cover up his ownership interest. Judge, it's not hindsight for Ally would have clearly been to disclose it and have it awarded to him or have it valued at some point. But at this point, taking the steps of not disclosing it and hiding it, only to be discovered years later that they did in fact have an ownership interest. We've set forth much of the law, and I won't belabor the point, but her due diligence was quite tenacious, as you saw through the discovery and the depositions, trying to uncover the ownership. I will note that the LinkedIn page, ERM has testified that she searched, she could not find anything, because she had searched, she would search the internet all the time for anything that would indicate any type of ownership interest. Those 2014 allegations of some type of thing, there's no evidence that those were actually on the web at that time. And we can find no proof that they were actually on the internet in a findable form to where anybody could find them.
All right. If you don't need the document that you have up on the screen, I could see it better if you took it down. If you need it, you're welcome to leave it up.
Okay. I appreciate you commenting on that as I navigate.
Did it. Thank you.
Thank you, Your Honor. I really do appreciate your patience. With regard to fraud and constructive fraud, the duty of limitations did not begin to run until 2019. Once again, fraud doesn't run limitations until the person is able to have been found out through due diligence that the fraud had committed. And we cited the cases.
What about that email?
Yes, that is an email. We addressed that extensively in our response, Your Honor. She was lashing out. As I said, she made that statement, but there's no proof in the summary judgment record that ERM had knowledge that Ally owned any interest in Flux 7 when that email was sent. She was lashing out and angry, but as we've said, we could not find any evidence that ERM knew he had an ownership interest in Flux 7. She had conducted her due diligence of that by having him swear under oath that he did not own anything in his inventory, and he swore under oath that he did not have any ownership in Flux 7. He had no hope of it, and he had never had any hope or promise of an interest.
But as of May 28th of 2014, she emails him saying, half of your shares of Flux 7 belong to me legally.
Correct.
So how is it that doesn't start the statute of limitations?
Your Honor, because at that time that was granted, that was an angry email that was sent. But once again, there's no proof that he had any ownership interest in it. There was nothing. She had already done her due diligence by conducting discovery and having his sworn. But
the statute of limitations doesn't start when you have proof. It starts when you have a belief or a reason to believe, right?
Yes. However, she had no reason to believe because she had hired lawyers and conducted discovery. And I know Mr. Hussein.
But doesn't that statement in the email say otherwise?
Yes, but you have Mr. Hussein who's swearing under oath that I don't own an interest in it.
Right. So there's a dispute. No question about that. But there's an email from her saying half of your share of Flex 7 belongs to me legally, and I might decide to make that an issue. So how does that not mark the beginning? Well, has that not specific enough to have that be the beginning of the discovery?
Well, I'll say she was even inquiring while before that email was sent.
But that email says, I own half your share. It doesn't say, if you own anything, blah, blah, blah. It's pretty definitive, that statement that I own half of what you own. And I could make an issue of it. But then she waits until 2020, 6 years later, to make an issue of it.
Well, that's not accurate, Your Honor. She made an issue of it in the divorce by conducting discovery and asking specific questions under the oath while the divorce was pending. You can't reward somebody who's going to fraudulently conceal something, and that would toll the limitations period, Your Honor, saying, I mean, she did is what every divorce lawyer would do in that case, which is you take the depositions, you get them sworn under oath, you get their sworn inventories, you conduct discovery, all flat out fraudulent allegations. Now she can pop off and say, I think you own it, but she had no proof whatsoever. Even as of today, Judge, the only way we found out about this was their own admissions.
Well, but their admissions,
yes,
their admissions are not that he owned it as of the time of their marriage, but that he owned it after marriage. And she says half of your share of Flux 7 belongs to me legally, which is not a you might own it kind of statement. It's a more definitive than that. And I suspect, well, it doesn't matter what I suspect.
And Judge, the fact your own question, I think, answers your question. Is she's saying that you own it, is the way you're saying it. And Ali Hussein is swearing under oath, I don't own it, and I have no documentation to prove it. The
Mr.
evidence we believe. I'm sorry.
Sorry to interrupt. I just wanted to give you a 5-minute warning.
I appreciate it very much. Thank you. That if she makes a statement and that they swear under oath, and they swear under oath till today, that they do not own, he did not own an ownership interest at the time. And Your Honor, I'm going to respectfully disagree. I think the evidence is quite compelling about the ownership from the beginning and 50-50 partnership. And I believe that creates a fact issue for the trier of fact to believe, especially given the standard of review in a summary judgment proceeding. But to say that she made the statement about the property, but she had no proof of it. That's why she didn't file a lawsuit. As soon as she heard the admissions that Ali Hussein had sold his interest in Flux 7 and heard the statements that they were 50-50 partners from the beginning, and they've advertised on the LinkedIn that they were co-founders from April of 2015, and this sworn testimony that they were 50-50 from the beginning. I certainly believe there's more than substantial evidence to get past the summary judgment for a fact finder to determine whether they're going to believe Ali Hussein and Atar, close friends who developed a business together, and their self-serving biased testimony. That is our position, Your Honor.
All right. So just for my edification, y'all have a trial setting for February 12th. How long is it set for?
Christy or Miss Rivers, I don't mind I think we have 3 days, maybe 2-3 days.
What do you all have left to do to get ready for trial?
I don't think much.
And the reason I ask is because I've got about 10 things ahead of you on my under advisement list. I'm working really hard to get through them, but I spend so much time on the bench, there's not a whole lot of time to get to them. So that's I'm just wondering if it takes me a few weeks to get to this, am I impeding your discovery or something else that you need to be doing?
Judge, the one thing that is preliminary to preparing for trial, which is in early February, is our scheduling order agreement that the parties might, if they choose, have another mediation. I don't think that is, I don't know. I don't know that we think that that would be helpful. Frankly, what would be helpful was the court's granting of the motion for summary judgment so we could get straight to the legal issues. But the court asked, and the sooner we know what's happening here, the sooner we'll know what would be next.
And as far as the summary judgment goes, this is an all or nothing summary judgment motion, right?
Yeah, it is, except for the claims for attorney's fees. Yeah.
Okay. All right. Well, so thank you, Mr. Michelle and Ms. Rivers and Ms. Block.
Can I
have 3 minutes left.
I'm going to be quick, Judge. One thing I have to address right at the outset is you asked a question about is half of what Ollie got in the sale of the company in 2019, is that what's in dispute? And the answer to that is theoretically that's what's in dispute, but the dollar amount is absolutely wrong. You do not look at the value at the time of the sale. You look at the value if Iran were to prevail at trial, all she could get would be half of the value of Ollie's interest in Flux 7 at the time of the divorce. And that's even true in a partition action. The increase in value from 2013 or 2014 to 2019 occurred while Ollie was putting in his sweat equity into the company as a single man after the divorce. So I want to make clear that there's a much smaller dollar amount at issue. And I want to go a couple of procedural matters first on the timeliness of the objections. That's an easy answer. I'd point to the case of Shelton versus Sargent, 144 Southwest 3rd 113. It's a 2004 case out of Fort Worth, PET denied. And it clearly says that objections to the summary judgment evidence can be asserted as late as the day of the hearing, and sometimes even later. The other procedural matter is we certainly do have some new grounds for summary judgment. So all of our grounds that we are bringing before you today were not already heard by Judge Rose. That includes, for example, the argument that the decree on its face awarded Ollie the asset that's in dispute. That's a new ground. And then another new ground is our traditional motion for summary judgment on the fact that he did not own any interest in Flux 7 during the marriage. We moved previously on no evidence, and now we're reasserting our no evidence and also adding a new traditional summary judgment motion on that. Very quickly on the substance, on the merits of the arguments, our first ground that the decree already divided what's at issue. Judge, you just need to look at the broad language of the decree. I thought I had it pulled up, but I don't. It's very broad. It's all benefits arising out of his past, current, or future employment. That couldn't be any broader.
He argues that it's limited by the heading. But this is a retirement benefits paragraph. At least that's my interpretation of what he was arguing.
He gets that from the family practice manual, which of course is objected to, not otherwise. And we all know that we don't use that when we have all-inclusive language that we want to be broad enough as this is.
And Judge, my argument is a little, I think they're trying to lead you down an extremely dangerous path that you're going to sneak in a business interest under a retirement paragraph. It's a very dangerous precedent. I think the court would be being pushed out on a ledge to say that to contort that paragraph, an award of sums is from employment benefits is somehow an award of an interest in a business.
A couple of responses. First of all, there are no headings. It's the heading is all property to the husband. And then it has 1, 2, 3, 4, 5, 6, 7, 8, 9 paragraphs. We're focusing on paragraph 4. And he's mentioned paragraph 8, which does specifically discuss rambling walk. But paragraph 4 is not just all sums. It's all sums. It's all any other rights. It's or other benefits existing by reason of the husband's past, present, or future employment. And that is as broad as it could possibly be. And Judge, you can look at the language and it speaks for itself. On the second ground of no ownership during marriage, they say time and time again, both in the presentation this morning and also in their response, they lump together this allegation that Ollie had an ownership or a hope of an ownership in Flux 7. And I want to break those down because, first of all, let's look at actual ownership. There's no evidence whatsoever that he actually owned any interest in Flux 7 during the marriage. That's our no evidence motion for summary judgment. In our traditional motion for summary judgment, we have presented what we believe is conclusive evidence that Ollie did not have any actual ownership interest in Flux 7 until after the divorce. Has she raised a fact issue? No, she has not. Her only proof is surmise, suspicion, sort of piecing together these long after the fact statements in an interview about co-founder, and in the beginning, they're trying to mix and match. They can't link it up. They just cannot connect the dots.
All right. Well, I think we're out of time. We're out of time, and I do have some other folks waiting in the wings, so to speak. So I am going to take this under advisement. I will try to get you a decision as quickly as I can. My goal is to clear out all of my matters under advisement by the end of the year. But as I say, there are a number ahead of you. So I had that one. I sometimes have these bad weeks where I get just a ton of summary judgment motions, and it just takes me a while to dig through them. So
Your Honor, I just want
thank you all for your arguments. They were very helpful. And unless y'all have something else, y'all are excused.
Your Honor,
Thank you, Your Honor.
I just want to say it's my first time appearing in front of you. I want to appreciate the older I get, the much more appreciate the cordial professional banter between the parties, and Your Honor, thank you for being patient with me.
All right. Well, thank y'all. Y'all are excused.
Thank you.
And Your Honor, may I ask a quick question before we begin?
Of course.
Thank you. Judge, we are dealing with a protective order. There are some sensitive subjects on here. I'm not sure about this court's policy. I know some courts generally do not publish this on YouTube in regards to this matter. I, of course, have no objection if we want to go on. But I do want to tell the court that we are dealing with some sensitive subjects, and I'm not sure if the court wants to continue publishing this on YouTube as we move forward. Of course, it's the court's decision.
Well, so the court's position is that we generally do publish or live stream our Zoom hearings on YouTube to comply with the open courts provision with the Texas Constitution. However, there are certain cases in which there may be sensitive information. Generally, that's limited to cases where there are teenagers involved who might get on YouTube or whose friends might get on YouTube and see their parents or their friends' parents discussing sensitive matters about the kids. So if there is some reason that either of you object to live streaming on YouTube, this would be the time to voice those objections.
No, Judge. I don't believe we have any objection. I just did want to bring that to the court's attention. I know some courts will automatically do that. So, okay, thank you.
Your Honor, I am very familiar with the nature of protective orders, and having to seek one. So if opposing counsel prefers that it's not live streamed, I have no objection to that.
All right. Well, I'm not hearing an objection from either of you. If we get into an area that you feel is particularly sensitive and that you prefer that we go off the live stream while we discuss that particular evidence, we can certainly do it then. But I hear no objection now, so we'll go forward. I have not had an opportunity to review the file. I do see that there is a related case. The related case, I guess, transferred in from Dallas back in July. Request for a de novo hearing brought by Mr. Gaddy. That's your client, Ms. Sherrod?
That is correct, Your Honor.
All right. Would you like to make a short opening statement?
Yes, Your Honor. Attorney Natasha Sherrod here on behalf of Christian Gaddy, the respondent in this application for a protective order filed by Alexis Moore. We are ready. Allegedly, there was a protective order issued in this case. My client did timely file a request for de novo hearing, bringing us here today. He has not had an opportunity to defend himself in regards to this application for a protective order. In fact, It is, he appeared pro se at the initial proceedings, and he was counseled by opposing counsel in regards to the protective order without fully, of course, he did not realize that opposing counsel's interests, of course, were with his client, the applicant. So we are here today seeking an opportunity to have a hearing on the application for protective order. It is our position that he was not afforded a hearing prior to today. Instead, he was, as I say in quotation marks, counseled by the opposing counsel, the applicant's attorney, in regards to whether or not he should agree to seeking a protective order.
And when was it? I'm
He
sorry.
became counsel, and we're here today. I apologize, Your Honor. I did not hear you.
So we do need to be careful not to speak at the same time because Ms. Williamson can't make a record when we do that. I apologize for interrupting. I just wanted to find when it was. Let's see. It says November 9th. There was of 2023, there was a hearing, and that was in front of which judge?
Your Honor,
Go ahead, sir.
I'm sorry about that. Judge, I believe we're actually reset from November 9th, and our hearing took place a little later in November. But the actual hearing, when it did take place, it was in front of Judge Arth.
And I believe the hearing occurred October 25th.
That sounds about right, yes.
All right, give me a minute because I'm not seeing it in either file. So there was a show cause order issued on 10/25/23, and then on 11/9 says that Mr. Ilyansky appeared with counsel and that the father appeared pro se, and that Mr. Ilyansky announced an agreement on the record, recited the agreement. The court recited the firearms admonishment to the father. That was all on 11/9. And then the order was signed.
We never got a signed order, Judge, because the de novo was filed, and when I checked with Judge Arth's coordinator, the coordinator told me simply to wait until the de novo was heard because Judge Arth didn't want to have an entry since we were so close to the de novo hearing.
That is my understanding as well.
All right. Well, so we are going to have the de novo hearing now. And so, Mr. am I saying that right?
Ilyansky. Yes, Judge.
Mr. Ilyansky, you may proceed.
Thank you. A brief opening statement, if allowed, please.
Yes.
Thank you, Your Honor.
I'll just tell y'all, Mr. Beck is keeping track of the time. Each side will have an hour on the clock, and y'all may use it as you like.
Thank you.
Thank you. May it please the court. Judge, we are here today on a protective order filed by Ms. Moore. This court will hear how Ms. Moore and Mr. Gaddy used to have a dating relationship. By testimony and evidence put on today, Ms. Moore will illustrate how beginning in 2018, Mr. Gaddy has repeatedly committed family violence as defined under Section 71.004 of the Texas Family Code. Ms. Moore, who became pregnant, attempted to save the relationship for the sake of their unborn child, only to continue to suffer more physical violence. Eventually, Ms. Moore ended the dating relationship and fled from the respondent. This court will hear how Mr. Gaddy then began a systematic campaign of abuse when he could no longer hurt Ms. Moore physically. Abuse which, again, fit the very definition of dating violence pursuant to Section 71.0021 of the Texas Family Code. This court will further hear and take evidence that when not stalking Ms. Moore, Mr. Gaddy busied himself advocating killing women on social media. This court will hear testimony and take evidence how Mr. Gaddy was warned by the police in Hays County not to come near Ms. Moore, only to immediately ignore that warning and be arrested. There are current charges for harassment. They're still pending in Hays County from Mr. Gaddy. This court will hear testimony and take evidence that once Ms. Moore filed for a protective order, Mr. Gaddy originally did enter into an agreement in regards to the protective order for a 5-year period, only to several days filed a de novo appeal, despite counsel's claims to the opposite, Mr. Gaddy was not counseled by opposing counsel. In fact, the parties took about 4 hours to negotiate and hammer out an agreement in the hallway. We're here for that de novo appeal today, Judge. We intend to show the court that Mr. Gaddy very likely suffers from mental illness. And frankly,
Mr. Eliansky, Ms. Williamson is trying to make a record and you're speaking extremely fast. And I'll just let you know that if somebody is speaking too quickly or if people are speaking over each other, she will shake her head as a verbal cue to remind you to slow down and speak one at a time. So I'll just ask you now to keep an eye on her as she'll cue you in on that. But in the meantime, please do slow down a bit.
thank you, Judge. My apologies. Your Honor, we intend to show that Mr. Gaddy likely suffers from mental illness and frankly has made Ms. Moore's life an absolute nightmare for years. So far, nothing has stopped him. Not requests of no contact from Ms. Moore, not a police warning, not even being criminally charged for his behavior. We are hoping that this protective order will allow some measure of protection against Mr. Gaddy for Ms. Moore. Thank you.
Your Honor, we would like to show that there has not been a history of family violence and that there is not a need for a protective order between the parties at all. In the alternative, we would argue that should the court find that there is a need for a protective order, we are asking that that protective order be limited in time to 2 years, rather than what I believe is currently sought by the opposing side, which is 5 years. We will show, the testimony will reveal that my client has not had any prior protective orders. And therefore, again, we're asking that in the alternative, should the court find that a protective order is warranted in this case, that it be limited to the initial 2-year timeframe. We're also asking in the alternative that the terms, the conditions in the protective order that are in place before my client can exercise his visitation with the child, who is not subject to the protective order in this case. She's not subject to the application for protective order. She is a 4-year-old child. We are asking that all conditions stated in the protective order that state those things need to be performed before my client can have visitation should not include that condition. In other words, should the court find that it's warranted for my client to attend any classes, that it does not require that those classes are completed or begun before he can actually exercise his visitation rights. As we have noted, there is a companion case. That companion case is for SAPSR, in which my client he initially filed that suit in order to be able to have visitation with his child. However, the items contained in the proposed protective order, those stipulations all require that these matters need to be conducted before he can actually see the child, and with scheduling and costs, that is in effect creating a protective order, if you will, that includes the child.
All right, I understand. All right, then, Mr. Eliansky, you may call your first witness.
Thank you, Judge. We call Ms. Moore. And how old are you?
Sorry, I'm not sure.
I'm 23 years old.
How do you know Mr. Gaddy?
He and I previously dated.
Okay. Did the two of you have children together?
Yes, we have one daughter.
Okay. How old is she?
She's 4 years old.
Were you and Mr. Gaddy ever married?
No.
But the two of you were in a dating relationship, correct?
Yes, that's correct.
Okay. When did the two of you begin dating?
And about July of 2018.
Okay. And did the two of you ever live together?
Yes, we did.
Okay. And we'll get to that in a second. Has there ever been violence during your dating relationship?
Yes, there has.
Okay. Let's go back to September 2018. Do you remember that month?
Yes, I do.
Was there an occurrence of violence at that time?
Yes, there was.
Okay, so let's start there. Can you please tell the court what happened in September of 2018?
Yes. Christian and I had went to celebrate Pride with a group of friends, and we had went to a bar, and we had all been dancing and enjoying ourselves, and Christian had gotten pretty intoxicated at a certain point, and we both decided that we were going to go to the bathroom. So he went to the men's bathroom, I went to the women's bathroom. And when I got out, I waited for him for a little bit, but I assumed with how long it was taking that he had already left the bathroom. And so I went to look for him, and I found him with our group of friends on the second balcony of the club. And he looked very distraught, very disheveled. And I asked him what was wrong. I was trying to offer comfort to him. He started mumbling some things under his breath. I don't recall what it was, but before I knew it, his hands were around my throat and he was strangling me.
Okay, and how long did this last?
I would say for approximately like 30 seconds or so.
Did he block your ability to breathe?
Yes.
And what happened after that?
After that, I got him off of me. I pushed him away from me. I ran down the stairs and outside of the front of the club.
And what happened after that?
After that, one of my friends, Josh, who had been there and seen the encounter, came outside and offered me support. And Christian followed not too long after. He had been screaming and crying and apologizing and hitting himself, and yeah.
Okay. And approximately what time of the day or evening did that occur?
It was really late at night at this point. I would say it was either maybe like 11 p.m., maybe even into the early morning of the following day.
Now, we might come back to that, but let me ask you this. You had mentioned earlier that you were pregnant. You became pregnant in your relationship with Mr. Gaddy, correct?
Correct.
When did you get pregnant?
I found out I was pregnant in October of 2018.
And how did Mr. Gaddy feel about this?
He was not happy with the fact that I was pregnant or my choice and wanting to keep it.
Okay. What did he urge you to do, if anything?
He wanted me to get an abortion.
Okay. And what happened when you refused?
There were several arguments that we had after that. And during those arguments, he would knock things over. He would ball his fists at his side and like feign to hit me when he was yelling at me about it.
Okay. How did that make you feel?
It made me feel really scared.
Okay. Did you continue to stay in the relationship at that point?
Yes, I did.
Why?
Because I wanted Ava to have the chance of growing up with both of her parents together and present.
Okay. And I'm not sure if you mentioned this before, but Ava, is that the name of your child?
Yes.
Let's move forward to January 2019. Okay. Do you remember that time?
Yes.
Okay. What, if anything, had changed in Mr. Gaddy's behavior around that time?
He began drinking to excess pretty much every single day.
Okay. And was there any further violence at that time?
Yes.
Can you please tell the court what happened on January 14th, 2019? Do you remember that day? Ms. Moore? If you shake your head, the stenographer can't see, can't put that down. So you have to make a verbal answer. Okay.
Yes.
Can you tell the court what happened January 14th of 2019?
On or about January 14th of 2019, Christian had told me that he was going to go for a walk, which at this point I had kind of come to the realization that when he said he was going for walks, that he was actually walking to a gas station that was close by so that he could purchase alcohol. And he was gone for a while. And when he came back, I heard him come through the door. And so I went to the top of the loft staircase. And as he was coming up the stairs, I could just see in his physical appearance that he was intoxicated. He seemed to be very pale and have rosy cheeks, which is pretty much a sign that I could tell. And so I told him, I was like, I can tell that you've been drinking. And we had already had conversations at this point about him getting intoxicated and about how often he was getting intoxicated. And he got very angry that I had said anything to him about it. He charged up at me from the bottom of the stairs to the top to where I was at. And he grabbed my shoulders and he began shaking me and screaming in my face, telling me that he hadn't been drinking and that I just needed to believe him. And, he was trying to do better. He was trying to be better. He was trying to be a better person.
Okay. Now,
things of that nature.
So did he physically make contact with you?
Yes.
Okay. You said that he was shaking you, correct?
Yes.
Okay. Were you pregnant at that time?
Yes, I was.
How many months were you pregnant?
I would say about 4 months pregnant.
Okay. And Mr. Gaddy knew this, correct?
Correct.
I'm sorry, I didn't catch the answer, the number of how many months she was pregnant, and I apologize.
About 4 months.
And were you living with Mr. Gaddy at that time?
Yes, we had our own apartment.
Let's move to the next incident that you listed in your affidavit, May 2019. Do you remember that?
Yes, I do.
Okay. Can you please tell the court what happened in May of 2019?
In May of 2019, Christian had been sitting on the bed. He was fairly intoxicated.
What time of day was it?
Evening, late evening, almost night, I would assume.
Okay. And where were the two of y'all?
We were in our apartment in Irving.
Okay. And was there any particular room in the house or in the apartment you were in?
We had a lofted apartment, so we were on the second story in our bedroom.
Okay. Can you please tell the court what happened?
He was sitting on our bed with his back against the headboard. He had been fairly intoxicated. He was talking to me about our friend Lizzie, who had...
Your Honor, I'd like to object to her use of the term intoxicated. That is a legal term that requires a certain blood alcohol content. Obviously, I'm an expert as to what his blood alcohol level contact was, so I would like to object to her use of the term intoxicated.
May I respond, Judge?
No, I'm going to overrule the objection and allow her to give a description based on her observations with the understanding that that is not an expert opinion.
Very well, Your Honor. Thank you.
You may continue, Ms. Moore.
We had been talking about our friend Lizzie, who had passed away. She had committed suicide in May of 2017. And he was expressing to me that he felt a lot of guilt and a lot of shame from her passing.
Objection, Your Honor, relevance.
Overruled.
You may continue, Ms. Moore, but go on.
I sat down across from him at the end of the bed, and I placed my hand on his knee, and I was trying to provide him with support to tell him that, you know, what had happened wasn't his fault, that he didn't need to be so hard on himself. And he got this blank look in his eyes. His eyes they just looked like they were void of anything. And he told me that he felt like he was switching, that he could feel his other personality coming forward, and that I needed to stop touching him.
And what happened after that, Ms. Moore?
As I withdrew my hand away from him, he reached across the bed and strangled me.
Okay. Did he strangle you with his left hand, his right hand, or both hands?
Both hands.
Okay. And how long did that last? Do you know?
I don't know.
Okay. What happened next? Oh, well, let me ask you this. Did he impede your breathing during the time that he was strangling?
Yes.
Okay. What happened after that? Do you
I
need a
was
second, Ms.
able
Moore?
to. Can I please just take just 1 second?
Your Honor, if I may request this.
Why don't we take a short break, about 5 minutes? You're welcome to turn off your cameras and microphones.
What happened after? Let's go back to that incident. I believe that was May 2019. What happened after Mr. Gaddy stopped choking you?
I promptly left the bedroom. I went into the bathroom and I shut the door and locked it behind me.
Okay. Were you scared for your safety?
Yes.
How many months pregnant were you at that time?
At this point, I was 7 months pregnant.
When did you give birth?
I gave birth in July of 2019.
Okay. Was there a time that you decided to end the relationship?
Yes.
Okay. When did you end the relationship approximately?
It was approximately June or July of 2020.
Okay. How did Mr. Gaddy take?
I'm sorry. Ms. Moore, your internet is a little affected after the break, but I didn't catch the year that you said just now.
I said approximately June or July of 2020.
How did Mr. Gaddy take the breakup?
He did not take it well at all whatsoever.
What did Mr. Gaddy begin doing after you broke up with him?
He began harassing me with phone calls and text messages, berating me.
Okay. Your Honor, may I share my screen?
You may.
Thank you. Screen now, Ms. Moore, you should be seeing text message screen. Do you see that? Yes?
Yes.
Okay, just making sure I'm showing it correctly. Okay. Let the record reflect that I'm showing Ms. Moore what's been pre-marked as Exhibit P1. Ms. Moore, do you recognize what this is?
Yes.
Is this a compilation of text messages sent by Mr. Gaddy to you?
Yes.
Okay. Are they true and correct versions of the text messages that you received on your phone at the time that they came in?
Yes.
Okay. Did you modify them in any way prior to sharing to the court here today?
No.
Okay. And do you know for a fact that this is Christian sending these text messages to you?
Yes.
And you know this because you've corresponded with Mr. Gaddy before and you had saved his contact information in your phone, correct?
Correct.
Your Honor, we move to admit P1, please.
Any objection?
No objection, Your Honor.
P1 is admitted.
Thank you, Judge. Okay. Ms. Moore, are these text messages from Mr. Gaddy?
Yes.
Okay. So how many text messages would you say you received an average per day from Mr. Gaddy once you broke up with him?
I would say approximately upwards of 20 to 40.
Okay. So if you can just start reading from where it says you are being the worst. Can you please read some of the text messages? Just keep reading until I tell you to stop, Ms. Moore.
You're being the worst. So that's it. You dump me and tell me you had a plan to dump me and then just never talk to me again. I know you're alive, at least as of yesterday. I don't know what the. Am I allowed to say that?
Yeah.
You could just say
Okay.
F or however you'd like.
Okay. I did to you to deserve you treating me the way you're treating me.
Keep going.
You're just a total piece of shit right now. Just pick up the phone. Ava would be so disappointed in you. At least I can tell her how hard I tried. F this, F you, F your constant hypocritical BS. Have fun. I'm glad you got what you wanted out of me till you could feel the void and dip, you absolute effing leech.
Okay, keep going. Oh, I'm sorry. Okay, just keep going start from I think I hate you.
I think I hate you. I really do. And it sucks because all you had to do was call me. I didn't ever mean a fucking thing to you. You're a coward. Have a good flight.
Okay. Now, are these all the text messages that Mr. Gaddy has sent to you?
No.
This is just an example, correct?
Correct.
Okay. Now, he would also leave voicemails, correct?
Correct.
1 second, please. Actually, look, I'm going to strike my last question. Would he call you as well?
Yes.
Okay. How many times would he call you per day?
I would say approximately 20 to 30.
And that's each and every day, correct?
Yes.
Your Honor, may I share my screen?
You may.
Okay. Let the record reflect. I'm showing Ms. Moore what's been trademarked as Exhibit P2 on the screen. Ms. Moore, recognize what this is?
Yes.
This compilation of the missed calls from Mr. Gaddy to you on your phone, correct?
Correct.
Okay. Is this a true and correct version of what you had on your phone prior to share, before you copied it to share with the court here today?
Yes.
Did you modify it in any way prior to sharing it with the court here today?
Not at all.
And again, you know this is Christian because you had him saved in your phone. That is his contact information, correct?
Correct.
Your Honor, we move to admit P2, please.
Any objection?
No objection, Your Honor.
P2 is admitted.
Thank you, Judge. Okay, so this is October 22nd, 2022, right? And all of these calls that came in are from Christian, correct?
Correct.
So we have 414, 415, 426, 427, 427 again, 430, 431, and 434, all within the span of that time frame from Christian, correct? So that's 1, 2, 3, 4, 5, 6, 7, 8, correct?
Correct.
But that's just one day, right? And if we keep going, we see Mr. Gaddy continue to make a number of calls, multiple calls on the same dates. Here's October 13th. And we have 9:28 to 9:49, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. 18 calls within the span of 20 minutes. Isn't that correct?
That's correct.
All right. But that's not it, because if we scroll down again on October 13th, there are approximately more than 10 more phone calls in the morning of October 13th. Isn't that correct?
That is correct.
And then we go on October 12th, and we have more missed calls, 4 of them. October 13th, 2 more calls. October 13th, 3 more calls. October 12th, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Might have missed that. 12 calls within the span of about an hour from Mr. Gaddy. Isn't that correct?
That is correct.
That's before you blocked his number. Isn't that right?
Yes.
And then did you start getting anonymous calls?
Yes.
Okay. Now, did you have good reason to block his calls?
Yes.
Okay. Did Mr. Gaddy leave voicemail on your phone?
Yes, he did.
Okay. Now, Your Honor, we have several audio files we'd like to play. That will be P3 through P8. I'm not sure if I should play them now, and if the court will hear them as I play them on my computer, or if the court would just simply listen to them on your computer, Judge. What is the court's preference?
First, we need to ask if there are any objections to P3 through P8.
And of course, I haven't authenticated yet, Judge. I'm sorry, I haven't put on the questions yet.
Right, but have you had a chance to look at them or hear them, Ms. Sherrod?
I have not, Your Honor.
All right. Well, let's go ahead and ask her the background questions.
Thank you, Judge. Okay, Ms. Moore, And I'm not going to share my screen at the time right now, but you're familiar with exhibits that have been marked as P3 through P8. Isn't that correct?
Correct.
Okay. Are these voicemails that have been left on your phone by Mr. Gaddy?
Yes, they are.
Okay. Do you recognize Mr. Gaddy's voice based on the what you hear on the voicemail?
Yes, I do.
And you're familiar with that voice because you know Mr. Gaddy personally, correct?
Correct.
Okay. Have you modified these voicemails in any way prior to, or these audio files in any way prior to sharing them with the court here today?
Not at all.
Okay. And are they true and correct copies of the voicemails as you have them on your phone?
Yes.
And are you familiar with how to download the files from your cellular telephone and present them to the court, correct?
Correct.
Your Honor, we move to admit P3 through P8, please.
Yes. Any
Yeah.
objections?
I apologize. I did not mean to interrupt you. Please continue.
Well, so the question is, do you have any objections to P3 through P8?
Yes, Your Honor, we do object. We have not had an opportunity to review these voicemails. We have no way of determining at this time whether or not they were doctored or not.
And Your Honor, may I respond?
Yeah, may.
Thank you. Your Honor, we uploaded these exhibits to the box before the hearing. Both attorneys have accessed the box and have time to review all the exhibits. And whether or not these have been doctored, of course, Ms. Moore just testified that they weren't. And of course, a fact issue whether or not they are indeed the messages from Mr. Gaddy, that's a fact question for the court.
All right. Well, I'm going to admit P3 through P8, and then we'll listen to them, and I will hear any specific objections to them after that and determine whether or not they should be handled differently.
Excuse
Okay,
me. I would just ask that before you play each file that you identify the file before you play it.
of course, Ms. Williamson.
Yes.
God, please answer the phone. Oh my God.
I'm going to go ahead and play P4. Okay, and then P5. Okay, and I'm going to play P6 and P7. And then P8. Now, is this a good sampling of voicemails that you received from Mr. Gaddy when he left you a voicemail, Ms.
Yes.
Moore? Okay. Did he harass any other members of your family?
Yes, he did.
Okay. Can you please explain for the court what you mean?
He harassed numerous of my family members, from my Aunt Trina to my Aunt Sharon, reaching out to them via text, through social media, calling them, leaving voicemails. Same thing with my friends as well.
Okay, we have Miss Williamson shaking her head, so slow down just a bit, Miss Moore. Please
Okay.
continue.
He did the same to numerous of my friends as well, reaching out to them in the same manners.
Can I get
It's 12:31, and as I mentioned, I have a 12:45 meeting I need to jump on to in a few minutes. You're about to ask for your time,
Yes, Judge.
Mr. Beck.
Counsel, you've got about 15 minutes left, and counsel for Mr. Gaddy has about 29 minutes left.
Thank you.
All right, so we're going to take a break until 1:15, and then we will continue on until we're done.
Yes, I can hear you.
What happened October 8th of 2022?
On or about that date, he came to my residence in Kyle, where he knocked on my door, looked through my windows, went through my back gate, and also spoke to my neighbors.
Okay. Did you ever give Mr. Gaddy your address in Kyle, Texas?
He had my address in Kyle, but not my address in Travis County.
Okay. And did he continue showing up at that residence?
Yes.
Okay. I'm gonna go ahead and share my screen. And eventually, did you complain to the police that he wouldn't stop showing up at your residence?
Yes, I did.
Okay. Did the police give Mr. Gaddy a warning?
From my knowledge, yes, they did.
Okay. Did Mr. Gaddy stop showing up at your residence?
No.
Okay. And in fact, Mr. Gaddy was charged for harassing you in his county, is that correct?
Yes.
Your Honor, let the record reflect that I'm showing Ms. Moore what's been pre-marked Exhibit P9. This is a certified copy of the information chargeable from Hayes County. We move to admit P9, please.
There's nothing on the screen, Mr. Lewandowski.
Thank you. Your Honor, we move to admit, please.
No objection, Your Honor.
Okay. And this
P9
is
hang on. P9 is admitted.
okay. And Ms. Moore, can you just very quickly read where it begins with Christian Patrick Gaddy on or about?
Christian Patrick Gaddy on or about the 14th day of October 2022 in Hayes County, Texas, whose torment or embarrass Alexis Moore caused the telephone of Alexis Moore to ring repeatedly.
I'm sorry, Mr. Lewandowski, I'm going to have to ask you to ask the witness not to read it quickly so that I'm able to make the record. That was terribly fast.
Okay.
I'm just going to strike my question. Was Mr. Gaddy charged for harassing you for continuing to call you repeatedly?
Yes.
Was he charged with harassing you for continuing to show up at your residence even though you told him not to?
Yes.
Okay. Now, you had mentioned earlier that sometimes Mr. Gaddy would say that his other self is taking over. So I want to talk about that very quick. Let the record reflect that I'm showing Ms. Moore via Zoom what's been pre-marked Exhibit P11. Ms. Moore, do you recognize this exhibit?
Yes, I do.
Okay. Is this a collection of text messages from you to Mr. Gaddy, from Mr. Gaddy to yourself?
Correct.
Okay. Have you modified these in any way prior to sharing to the court here today?
No, I have not.
Are they true and correct versions of the text messages as you received from Mr. Gaddy?
Yes.
Your Honor, we move to admit, please.
Objection, Your Honor. There's no timestamp that I can see. I'm not sure what date this occurred. These text messages are from.
May I respond, Judge?
All right. So the objection is that there's no timestamp. And so why don't you go back and lay the foundation for that?
Yes, Judge. Ms. Moore, approximately when did you receive these text messages? From approximate what date to what date?
This was approximately in, I would say 2019, maybe October to November.
Okay. And do you know for a fact that this is Christian sending these text messages to you?
Yes.
And you know that because you have saved his number in your phone, correct?
Correct.
And I see actually it says here Christian's old number, correct? That's before he changed the new number to start stalking you on the new number, correct?
Correct.
Your Honor, we re-urge to admit, please.
Any objection, Ms. Sherrod?
I object that the text messages are they're just I just don't think they're relevant. And if they're being offered, you know, again, for the truth, I have no way of verifying that these are actually from 2019. I don't think that counsel has fully laid the predicate for these to be entered, Your Honor.
May I respond, Judge?
Not necessary. The objections are overruled. P11 is admitted.
Okay. Ms. Moore, Can you please start reading from where it says cause you're dating someone?
Yes. Because you're dating someone with
All right, so we're having that problem with your audio,
schizophrenia.
Miss
I'm
Moore.
asking for reassurance because after last night, I can't think for myself.
So,
Okay.
Miss Moore,
Okay.
I don't know what happened to your audio over the break, but it's not good, and I don't know what to tell you except maybe try to log out and log back in. That sometimes helps.
Please go ahead and read that paragraph.
Because you're dating someone with fucking personality disorder and schizophrenia. I'm asking for reassurance because after last night, I can't think for myself. I'm asking for reassurance not because
Thank
I
you.
don't have.
Okay. And I want you to read a text message that begins with I have.
I have schizophrenia and it's bad today, Alexis.
Okay, stop right there. Okay. I want you to read where it begins with what you are not understanding.
What you are not understanding about I have schizophrenia, things like this burrow into my head and it burns.
Okay. Can you please read here where it begins with I told you I am?
I told you I am myself and you want to leave me alone.
And can you please read where it begins with I need, I love you a lot?
I love you a lot, but I'm losing 100% of my S. I need help. I need help. I need help. I need effing help.
Okay, and you respond with?
You need help, question mark.
And how does Mr. Gaddy respond?
I'm going to F myself. I cannot.
Okay. Now I'm scrolling, for sake of time, I'm going to keep scrolling and then start reading with it's not me.
It's not me.
And what do you
mean?
And how does Mr. Gaddy respond?
I'm having problems with y'all speaking at the same time, and on Zoom, that means I'm getting not much of either of you. So if you can please speak one at a time, it will make me be able to make your work.
Thank you, Ms. Williamson. My apologies. Ms. Moore, can you go ahead and start with I can't help it?
I can't help it. I can't. It's the way my brain functions. I have schizophrenia and it's bad today, Alexis.
Okay. I'm going to stop sharing my screen for now. Now, after the protective order was issued, the one that was agreed upon, has Mr. Gaddy abided by that protective order?
No.
Okay. Can you please tell the court what you mean by no?
I believe that I saw his truck outside of my house after.
Okay. When was that approximately?
I believe it was on the 10th.
Of when?
Of November.
Your Honor, I'm going to object to sidebar by Mr. Gaddy. Mr. Gaddy is making facial features, shaking his head, so I'm going to object to that. I guess it was.
Sorry. Yeah, I'm going to ask that you not be making faces or shaking your head, Mr. Gaddy.
I understand, Your Honor.
Ms. Moore, when did you see Mr. Gaddy in his vehicle outside your apartment?
It was at my house, and I believe it was November 10th.
Okay, was that the day, literally the same day as the protective order?
It was the day after.
Okay. What kind of vehicle does he drive?
A blue F-150.
And you even took down the license plate, isn't that right?
Correct.
Do you remember the license plate?
Yes.
What is it?
9.
Okay. Now, Mr. Gaddy, does he have a gun?
Yes, he does.
How do you know?
I've seen it.
Okay. And in fact, in the protective order agreement, did Judge Arth instruct Mr. Gaddy to get rid of his firearm within 3 days of the order? Correct?
Correct.
Okay. And to send a written notice to your attorney and yourself stating what he's done with the firearm. Isn't that correct?
That is correct.
And you have not received such a notice. Isn't that correct?
Correct.
Has Mr. Gaddy ever posted anything on social media which worries you? It doesn't necessarily have to do with you specifically.
Yes.
I'm going to go ahead and share my screen. Your Honor, let the record reflect that I'm showing Ms. Moore what's been pre-marked Exhibit P10. Ms. Moore, can you please tell the court what we're looking at? very briefly?
We're looking at a video of a man rejoicing in the fact that he shot a woman for entering his home.
Okay. Where did you get this? Where's this where's the screenshot from? Is it a social media?
This is directly from Christian's Twitter.
Okay. And is this a true and correct version from his social media post on Twitter as you remember it?
Yes.
Did you modify it in any way prior to sharing it with the court here today?
Not at all.
Your Honor, we move to admit P10, please.
Objection, Your Honor, predicate lacks foundation. I do not believe counsel has elicited how we are to know that this is from Christian's page. His name is not on here. There's nothing to show that this is related to him.
I'm happy to lay down more foundation questions, Judge.
Okay, go ahead.
Thank you. If we scroll to the second part, does this say Christian, Ms. Moore, right here?
Yes, that's correct.
And we have a hashtag, I guess, whatever it's called Beast Mode Gaddy, correct?
That's his username, correct?
Okay. Do you know that for a fact?
Yes.
Okay. And how do you know that?
I followed him on that account at one point.
Okay. Your Honor, we urge to admit Exhibit P10, please.
Any objections?
No objection, Your Honor.
All right, P10 is admitted.
Ms. Moore, this is a video of a man. These actually several videos and posts of individuals talking about physically assaulting and killing women. Isn't that correct?
Correct.
And on one of these, there we see somebody saying, "I shot her anyway." And how does Mr. Gaddy respond?
He responds by saying legend.
And on the next post, there is somebody says headshot on the tramp, and we have a photograph of a woman that's obviously in distress in a bloodied dress. And how does was this on Mr. Gaddy's social media?
Yes.
So he shared this, isn't that correct?
Correct.
Okay. Do you find this distressing?
Yes, I do.
Now, are you afraid of Mr. Gaddy?
I'm absolutely terrified of him and what he's capable of.
Okay. Do you believe that Mr. Gaddy's conduct will continue?
Yes. Has
it continued?
Yes.
Okay. If we have time, are there any other family members that have also witnessed Mr. Gaddy being near your current home after the protective order?
Yes.
Okay. Do you believe that Mr. Gaddy's actions will have done you physical harm?
Yes.
Do you believe that Mr. Gaddy's actions in the future will place you physical harm if he is not stopped?
Yes.
Have they caused you bodily injury?
Yes.
Have you been assaulted by Mr. Gaddy?
Yes.
Did his actions place you in imminent physical harm, bodily injury, or assault by him?
Yes.
Do you believe him to be a threat that reasonably places you in fear of imminent physical harm, bodily assault, or injury?
Yes.
Mr. Gaddy has a concealed permit to carry, isn't that correct?
Yes.
Okay. Now, Your Honor, I'd like to reserve the time that I have left for a closing, unless the court would allow me to do the closing if my time has run out.
All right, how much time does he have left, Mr. Beck?
About 1 minute, Judge.
All right, well, let's go ahead and save that.
Oh, and a Judge, I'm so sorry. I had one more question, obviously. I forgot one more question to ask of Ms. Moore.
Go ahead.
Thank you. Ms. Moore, are you asking that the court grant you the protective order and give you the relief that you're asking for the court here today?
Yes, I am.
Thank you. I'm going to pass the witness, Judge.
Alexis, have you made any police reports regarding your belief that you saw Mr. Gaddy or his truck outside of your house after November 9th of this year?
No.
Okay. And Alexis, I want to go back to the very first incident you referred to in your unsworn affidavit. Back in September 2018, you stated that an occurrence, your alleged incident of family violence in a nightclub in Dallas. Is that correct?
That is correct.
What is the name of that nightclub?
It starts with station. I believe it was station 10 or station 4, one of those two.
And you mentioned that at some point you were on the second story of the nightclub.
Yes.
Is it a two-story club or more stories?
So they have one story that's inside, and then they have like an upper patio that's kind of outside, halfway covered.
Okay. And on that night, you stated you were out with a group of friends. How many friends?
I would say approximately 5, I believe.
And are these your friends, Christian's friends, or mutual friends?
Some of them were mutual, some of them were mine.
Out of the 5, how many were your friends?
2.
Okay. And you stated that Christian violently choked you or strangled you on the second story. Is that correct?
That is correct.
Did you make a police report?
No, I didn't.
Did your friends make a police report on your behalf?
No.
Okay, you stated that the evening ended with, I guess at some point, Christian left your residence, the shared residence that you had. So how did you get from the club to your residence?
Our friend Josh had taken us back to our friend's house that we originally met at, and then we Ubered from there to my apartment that I was living at with my aunt at the time.
Okay, and would you say Josh is one of those mutual friends, or is Josh one of your 2 friends?
Josh is one of my friends.
Okay, and this would be the same Josh that you stated, I guess he came outside when you were in the front of the club. Is that correct?
That is correct.
Okay, so it's your testimony that after your friends, including Josh, witnessed this incident in which you were violently choked, then that same individual transported the 2 of you back to one residence, and then later you traveled home together. Is that correct?
Correct.
Okay. You also described an incident that you state allegedly occurred in May of 2019. Again, you state that you were strangled by Christian and that your breathing was impeded, correct?
Correct.
And you were 7 months pregnant at the time?
Correct.
Did you make a police report?
No, I didn't.
Okay. Were you still going for your prenatal visits?
Yes.
Okay. I want to go back to January of 2019. You alleged that Christian grabbed you by the shoulders and shook you, and you were 4 months pregnant at that time, correct?
Correct. I would say that. Yeah.
Did you make a police report at that time?
No.
Okay. And were you still going to your prenatal visits?
Yes.
Okay. And at these doctor's visits, don't they normally ask whether or not you are in a violent relationship?
Objection,
I was
Your
not
Honor.
asked.
I'm going to withdraw my objection, Judge.
When you went to these prenatal visits, did you ever mention being in a abusive or violent relationship?
No, I did not.
During these prenatal visits, did you ever express concern about having your breathing impeded while pregnant? And did you ever express concern during those visits?
No, I did not.
Okay. Did you ever express concern about allegedly being shook by the shoulders?
No, I did not.
Okay. Now, Ava was born in July 2019, correct?
Correct.
Okay. And you stated that you believe that you and Christian broke up about a year later, July of 2020.
Mm-hmm.
Now, that in fact was the first of a series of breakups, correct?
Correct.
And would you say or agree, well, when would you say was the final breakup?
We had tried again briefly after that, in like January of 2021, and I called it off. I think it was May or June 2021. I honestly, that time frame is a little bit fuzzy, but I believe it was about that.
Okay. Would you be surprised if you and Christian, in fact, had an on and off again relationship until about October of 2021?
That's not correct.
Okay. Now, during the time at this on and off again breakup, would Christian see Ava?
Yes.
Yes, Your Honor, as to relevance. And Your Honor, I do want to add that the two cases that we have, they have not been consolidated in any way. The parties did reach an agreement as to both last time they were in court, but we're here only on the protective order only.
Right. So I didn't actually, and the court reporter did not actually catch the whole sentence, but the question about whether what was happening with their daughter isn't really relevant. I agree. I sustain that objection.
So it's your testimony that you have been afraid of Christian since what, 2018, but you've never made a police report. You haven't informed your healthcare providers, and your friends that were present with you on at least one of these alleged incidents did not intervene for your safety. Is that correct?
Objection asked and answered and cumulative, Judge.
I'm going to overrule the objections. You may answer.
I'm sorry, can you repeat that question again? It kind of broke up a little bit.
Sure. It is your testimony that you have been afraid for your life since September of 2018, and that in that time frame, since then, you have not made any police reports, correct?
I have made police reports. That's how the case for harassment was brought upon.
I apologize. I'm referring to the incidents of actual physical violence that you have alleged occurred beginning in September 2018. You did not make a police report for any physical violence, correct?
Correct.
Okay. And in regards to one of these alleged instances of physical violence, it is your testimony that it occurred in a public place with your friends present, and no one intervened for your safety by making a police report, correct?
Correct.
Isn't it true that you're seeking this protective order to impede Christian's ability to see Ava?
Not at all.
No further questions for this witness, Your Honor.
All right.
Your Honor, I do have one quick question if the court will allow me.
Very quick.
Thank you. Ms. Moore, why didn't you contact the police about Mr. Gaddy's repeated physical offenses? Or why didn't you tell the physician?
I mean, he is the father of my daughter. I didn't ever want anything to happen to him, even though things happened to me during our relationship. I didn't ever want him to like face ramifications because of it.
Thank you, Judge. Pass the witness.
Anything further, Ms. Sherrod?
Nothing further for Ms. Moore.
All right. And you rest, Mr. Iliansky?
Yes, Judge, we do rest.
All right. You may call your first witness, Ms. Sherrod.
I'd like to call Christian Gaddy. Mr. Gaddy, do you believe Alexis is seeking this protective order to impede your visitation with your daughter?
Objection leading.
Sustained.
Mr. Gaddy, why do you believe Alexis is seeking this protective order?
To impede on my ability to see my daughter.
And what leads you to believe that?
The last time that I saw my daughter was September 19th of 2022. I have not seen my child, and I have not spoken to my child since October 21st of 2022. Those are my attempts of contact, and I've been begging to see my daughter just to hear her voice.
Okay. The question, let me rephrase my question. Was the protective order when was the protective order filed, before or after you sought visitation?
It was filed after.
Sorry, did you say sought or stopped?
Yes. S-O-U-G-H-T, sought. Christian, is there any other reason that you believe This is an attempt to keep you away from Ava.
Asked and answered.
I'll withdraw the question, Your Honor.
All right.
Christian, were you outside of Alexis's residence on or after November 9th of this year?
No, never.
How long have you, do you drive a blue Ford?
Yes, I do.
And how long have you had that vehicle?
I've had that vehicle since January of 2022, I believe.
Okay. And has Alexis ever seen you driving that vehicle before?
Yes.
And is there any way that she could have obtained your license plate number before November of this year?
Yes.
Objection to proper predicate. Your Honor, there's no personal
Overruled.
knowledge.
Overruled. You may answer.
Yes, it is possible.
Okay. And Christian, where do you live now?
I live in Dallas, Richardson. I live in Richardson.
And how far away is that from Austin, Texas?
About 222 miles away.
And are you currently employed?
Yes, I am.
And what type of work do you do?
I'm a warehouse supervisor.
Okay. And what days do you work?
I work Thursday, Friday, Saturday, and Sunday from 5:30 p.m. until 6 a.m.
Okay. Now, November 10th was a Friday. Is that one of the days that you work?
Yes, I had to take a leave of absence for the court case, though.
Okay. And as far as travel time, what time would you have to leave? I withdraw that question. I withdraw that question. Christian, you heard the voicemails that were played, identified as exhibits P3 through P8, correct?
Yes.
Do you, and in those, we heard a male voice crying, and the words stated were, please call me. Is that correct?
Yes.
Do you agree that that is your voice on those voicemails?
Yes, I do.
And were you calling, or did you leave those voicemails for the purpose to harass Miss Moore?
No, the purpose was so I could speak to Ava.
And at that time, how long had it been since you had spoken to Ava?
I hadn't spoken to Ava.
Objection after relevance, Judge.
Overruled.
At the time I left the voicemails, I hadn't spoken to Ava at all that month. It had been about 22 days.
And is that something that you're accustomed to?
No.
So prior to your final breakup, and I apologize, when do you think the final breakup occurred?
October of 2022.
Okay. And so, were you given any notice by Ms. Moore that you would not be able to talk to your daughter?
No, ma'am.
Or that you would not be able to see her, visit with her?
No, ma'am.
Prior to that time, though, you did have regular visits with her and contact with her, correct?
Yes, ma'am.
And did you also make wellness check phone calls through your local or through the local police department?
Yes, I did.
Your Honor.
Okay. I didn't know if someone else was speaking.
Judge, I did make an objection as to leading.
I didn't hear that, but it is sustained.
What other ways did you try to find out to check up on your daughter? What ways did you use to try to check up on your daughter?
I reached out to her aunt, Sharon Blankenship. I reached out to her other aunt, Trina. I don't know her last name. All in efforts to ask if I could just speak to Ava Rose.
Okay. And do you have you're currently in another relationship, correct?
Objection
Yes.
to deleting.
Do you have a desire to
Let
get
me-
back
sorry.
together with, I'm
Sorry,
so
it took me a minute to get to the unmute button. So the objection is leading, and I'm going to sustain the objection. So let's ask it a different way.
Christian? Are you, let me think about a different way to ask the question. Christian, do you have a desire to get back together with Alexis?
No, I do not.
What reason, if any, do you have to communicate with Alexis?
Just in order to speak to Ava and see Ava.
Okay, and would you be willing to use an intermediary to make arrangements?
Yes, I would.
And have you ever strangled Alexis?
No.
Have you ever taken any action to impede her breathing?
No.
Have you ever grabbed Alexis by the shoulders and shake her?
No.
Have you ever taken action to cause her fear for her safety?
No.
Are you schizophrenic?
No.
But have you ever said that you were?
I have.
Why is that?
I was desperate for attention. I just I needed attention from people. I was a teenager, not living in very great times, and I thought a mental illness at the time would garner me special attention from my peers.
You mentioned that you are a manager at your job.
Yes.
So you have how many employees report to you?
22.
Relevance, Judge.
I'm
Your Honor,
sorry.
I'm going to object as to relevance.
Overruled.
How many employees report to you?
22.
22 employees. What types of things are you responsible for at your job?
I'm responsible for all inbound product for HelloFresh. I am responsible for all outbound orders for HelloFresh. I am responsible for the safety and the well-being of all the employees on the floor. I am responsible for all standard operating procedures. And I'm also responsible for a lot of inventory counts.
How long have you had this position?
I've been employed with HelloFresh since September of 2021.
Okay. And have you ever had any disciplinary issues at your job?
No, ma'am.
Christian, do you do own weapons, correct?
Objections to leading.
I'll rephrase. Christian, do you own any weapons?
Yes, I do.
And are they currently in your possession?
No, they are not.
Christian, what is it that you're wanting to occur today?
I would like the court to recognize that I never meant Alexis any harm. I've only been looking for my daughter. I've only wanted to communicate with my daughter. All I want is to be a part of her life. I believe every child needs their father. I do not think that this protective order.
Narrative, Judge.
Overruled.
I do not believe that this protective order is warranted. I have no ill will towards Alexis. Even after all of this, I wish her nothing but good things. I just want to be in my child's life again.
Now, Christian, very briefly, I want to take you back to when you were in court I believe it was November, where you supposedly, I believe you agreed to a protective order. How did that come about, sir?
I thought it was my only option to see my daughter. I thought that if I didn't, I wouldn't have any rights as a father anymore. I didn't understand what was being asked of me. I made a horrible mistake.
Why did you believe that if you didn't agree to the protective order, you would be terminating your rights as a father?
I was, Mr. Ulinski, helped.
Your Honor, I'm going to object to any negotiation under TRE 408. So any discussion of negotiations is not admissible. I believe that's where the question was headed.
I'm going to overrule the objection. I'm going to allow him to answer the question.
Thank you, Judge. I kept going back and forth on my decisions on what I should do, and it was implied to me by Mr. Ulinski that this was my option. He proclaimed he is a father as well, and he acted as though he was distressed and annoyed with his client, Miss Moore. I thought he was trying to help me. I didn't understand his interests do not align with my rights as a father, and
So for the second time, I apologize, Christian.
it's okay.
And the court reporter is shaking her head.
And it's because when you speak at the same time, I can see everyone's lips moving and I hear nothing to write down for you. So it's very important in Zoom to speak one at a time.
And Mr. Rod, I'm sorry to interrupt too, and I'm sorry, Michelle, for crosstalk. I just wanted to let you know you've got about 3 minutes left.
Very well. Christian, when you agreed to or supposedly agreed to the protective order at that time, did you feel that it was warranted? Well, did you believe that that the accusations in Alexis's affidavit were true?
No.
Did you believe that you should be subject to a protective order for Alexis's safety?
No, not at all.
So your focus was purely on visitation for your daughter?
Yes, that is all I want.
When did you realize that this agreement for a protective order actually impeded your ability to see your daughter?
As soon as the court hearing was over, I got in contact with my mother, Julie Gilman, and I explained to her the stipulations for the protective order, and she explained to me very quickly how. Go ahead. Okay. She explained to me very quickly.
I'm objecting to hearsay, Judge.
Christian.
Sorry, may I get a ruling in my objection, Your Honor? My apologies.
Yes, the objection is sustained.
Thank you, Judge.
Very well. Christian, I have no further questions for Christian, Your Honor.
All right. Well, I believe we're about out of time. Did you have anything else you wanted to put on? Any other evidence, Ms. Sherrod?
No, Your Honor. Christian was the only testifying witness today, Your Honor.
All right. So both sides rest and close.
Yes, I do, Your Honor.
Yes, Judge, although if the court permits, I would like to make a brief closing argument, please.
Well, I believe we're out of time and I don't feel it's necessary. I am going to grant the protective order. There is a whole separate issue about the ability to see your daughter, Mr. Gaddy, and that is a completely separate issue from this. But the protective order is to protect Miss Moore. I am inclined to grant it just for 2 years. And then if there's any reason after 2 years to believe that any of this behavior may start again, or that it has continued in any way, I feel certain that a judge will be happy to grant an additional protective order. I'm hopeful that this 2 years will give Mr. Getty time to reconsider his behavior, and will give Ms. Moore some ability to feel safe. Do you have an order prepared, Mr. Leonsky?
No, Judge, I did not, because I didn't know the specifics of how the court would rule. I would ask if the court could specify on the relief that we requested, because we did request specifically about the firearms and other things. So if the court would be willing to rule on that as well, I can put together a protective order, a proposed order.
So I do intend to grant the relief requested with respect to the firearms. I do think that the judge who hears the issues related to possession and access to the child will need to work that through. Where would I find what you're asking?
Yes, Judge. Will be in the application for our protective order, which was filed on October 10th. I'm sorry, October 2nd. Well, it's in October of 2023, and it would be paragraph 14, which begins at the bottom of page 2.
All right, I will take a look at that after this hearing, and we'll let you know if there's any specific relief you've asked for, but I'm not granting. And but I do think there's sufficient evidence of family violence, and I hope that this protective order will ensure that that doesn't continue, and that any of the harassment or stalking behavior does not continue, and that y'all go deal with the issues relating to access to the child separately. I do agree that as long as Mr. Gaddy is complying with the protective order, and there is no evidence of any danger to the child, that he should have regular access to his child. She needs 2 parents. And although it's clear that she's not going to have 2 parents who are going to get along together, she needs 2 parents who at least are not openly hostile to one another, if she's going to grow up to be a healthy, well-adjusted person. So I hope that you all will work on that. I will get you a ruling on all the various issues, Mr. Leonsky and Ms. Sherrod, as soon as I can. All right.
Thank you, Your Honor. Should we contact the coordinator for an entry date then?
Mr. Beck will be in contact with you about when he wants to get a proposed order back, and when he will want Ms. Sherrod to either approve it as to form or send us a red line version of it. And then I don't anticipate that we'll need another hearing. We'll just, if hopefully y'all will agree on the form. If you don't, then we will look at Ms. Sherrod's red lines of Mr. Leonsky's order and make a decision about the form of the order and get it signed. And I'd like to get that done in the next week. All right.
One final question. Will this be sent via email or through the box?
Yes, it'll be sent via email.
Okay. All right. Thank you so much. I truly appreciate your time
All right.
and consideration.
Thank you all.
Thank you, Your Honor. We excuse.
Yes, you are.
Thank you, Judge. Have a good afternoon.